So we are live now.
गुड आफ्टरनून, नमस्कार। मैं सुनील गुप्ता, सेक्रेटरी वेस्ट डिस्ट्रिक्ट लीगल सर्विसेज अथॉरिटी, सभी लीगल सर्विस एडवोकेट्स का द लीगल प्रैक्टिशनर्स लर्निंग सीरीज के थर्ड सेशन में हार्दिक स्वागत करता हूं। देयर इज अ सेइंग इन लॉ दैट यू कैन नेवर नो एवरीथिंग अबाउट लॉ बिकॉज लॉ नेवर रिमेन्स स्टैटिक. It keeps on changing with changing needs and perspectives of society through legislation and judicial pronouncements. The objective of DSLSA behind this learning series is that our legal service advocates should be updated with latest amendments, trends, judicial pronouncements in different fields of law so that they can perform the duties assigned to them in a better way and we can fulfill our motto, that is access to justice for all. Today's topic of discussion is recent developments in Hindu Succession Act 1956. And to enhance our knowledge on this particular topic, we have with us Mr. Rahul Gupta, Advocate, Delhi High Court. I welcome Mr. Rahul Gupta, sir.
Thank you.
Sir, I am sure that your vast experience in this field is going to benefit all of us who are joining this session today.
Thank you.
So before I formally invite Mr. Gupta for sharing his thoughts on this topic, I would like to give a brief overview thereof. So Hindu Succession Act 1956 is one of the codified personal laws governing the people professing Hindu, Buddha, Sikh and Jain religion in this country. Passing of this act, along with 3 other acts, was considered as a bold step by the then central government, as there was fierce criticism of these acts. Main criticism, of course, was that enactment of these acts resulted in interference by government in personal matters of a Hindu, which were governed till then by religious practices. However, as the laws were ultimately passed, so the people had no choice except to obey the same. Section 6 of the Act recognized the concept of coparcenary as existing under Mitakshara school of law, but unfortunately, there was discrimination between male and female relatives. It was felt by certain section of people that the opportunity to rectify the pre-existing discrimination was missed by government, while another section was of the view that it was almost impossible to do so at that time. Finally, an amendment was brought in section 6 in the year 2005, giving sons and daughters equal rights in a joint Hindu family governed by Mitakshara law. But again, the question arose about applicability of amended law. One of the interpretations was that daughters' coparcenary rights, being prospective, would not come into effect unless both the copartner father and his daughter were alive on the date when amended law came into force. This view was taken by Honorable Apex Court in Prakash and others versus Phulvati in the year 2015. That judgment has been overruled last year by Honorable Apex Court in Vinita Sharma versus Rakesh Sharma. It will be interesting to see practical ramifications of this judgment, especially in the matters disposed of earlier on the basis of Prakash versus Phulvati judgment. Then there is issue of discrimination against females as far as inheritance of their self-acquired property is concerned. As per section 15, in case a female Hindu dies intestate, her property shall devolve on her children and husband. In case they are not there, then the property shall devolve on heirs of husband. People do have objection on this particular aspect on the ground that in such a scenario, her property should devolve on her relatives and not on her in-laws. There may be some change in this particular aspect also in near future, because there is a Latin maxim, "Cessante ratione legis cessat ipsa lex," meaning where the reason for the law ceases, the law itself also ceases. That's why amendments are carried out in law to keep pace with the demands of the society. So this was a brief overview of the topic. I know you all would be eager to hear Mr. Rahul Gupta, who is an expert on this subject. But before that, please let me give a formal introduction of our resource person in brief. Mr. Rahul Gupta is very experienced and senior lawyer practicing before Delhi High Court and Supreme Court of India since 1989. He has specialized in advising and handling legal matters of civil nature, with special emphasis in cases of Hindu law of succession and other related issues. He also holds command in matters of property laws and commercial disputes under contract laws, including Arbitration and Conciliation Act 1996. He is always inclined for advising and assisting his clients for amicable settlement, compromising, and mediation to settle the dispute in the overall interest of both the parties. So, with this brief overview, I am sure you would have got an idea as to how this session is going to proceed. This is going to be a wonderful, interesting, and informative session. So, without doing any much ado, I would now hand over the proceedings to Mr. Rahul Gupta, sir. Over to you, please, sir.
Thank you, Sunilji. Thank you very much by giving me this opportunity of addressing a very learned group of lawyers who have recently joined your platform of DSLSA. Now, coming to the subject of right of daughters in joint Hindu family property, the subject has always been very interesting since it concerns all of us in one way or the other, because we as Hindus are living in families, and these issues have always arisen in the past and at present, and they will keep arising in future. That what happens when there is a death of a member in a family and there are joint family properties left behind, then who all shall be entitled to succeed and inherit and claim partition of those properties. So, to make things more clear and simpler, let me tell my dear audience, my friends, that in law, generally speaking, we have two kinds of properties. One is a self property, and other property what we are dealing with in this subject is the joint Hindu family property, also known as co-parsonary property, also known as ancestral property, also known as Hindu undivided family property. So these are some broad terms which are used interchangeably whenever we are dealing with the subject of joint Hindu family property. Now, self-acquired property is a property which is acquired from the earnings of an individual, of himself, and he during his lifetime, from his own earnings and resources, acquires a property, buys a property. That is his self property. So in a self property, the succession goes separately and independently under Hindu law, for which we are not concerned in this session, as we are concerned with a joint Hindu family property. So what shall be a joint Hindu family property? In very simple terms, any property which I have not bought or acquired from my own earnings and resources, but I have inherited from my ancestors. So any property which has come down to me or which is going to be given to me in inheritance from my father or grandfather or maybe my great grandfather. So, to understand the concept of a joint Hindu family property, before we proceed to the rights of daughters, we may know that there is a concept of co-partnery under Hindu law. And all my dear audience, if they have some paper and pencil in their hands, they may just take down some notes, which I will keep telling them. Hindu Succession Act 1956 was first time codified law with respect to succession amongst the Hindus, how the properties will devolve, how the properties will be inherited by the legal heirs on the death of an ancestor. So, Hindu Succession Act was codified in 1956 and it came with effect from 17th June 1956. Section 6, if you may note down, is the heart and soul of this subject of co-partnership property, joint Hindu family property, and rights of daughters. Section 6 is the most important section in the old act also, and now in the new act after amendment, which is popularly known as Hindu Succession Amendment Act 2005, which has come into effect and implemented from 9th September 2005. So this date becomes important, 9th September 2005, that this very important amendment made by the Parliament, central government, has come into effect. Now, as I told you earlier, that any property which we are inheriting and acquiring from our ancestors is a normally known as joint Hindu family property and ancestral property, a co-partnership property. Now, to understand the concept of co-partnership, a co-partnership always begins with one common ancestor of the family, one single person who shall be at the top of the co-partnership, who would be generally known as Karta, and he would be the senior most living or dead eldest member from where the concept of co-partnership property began, the concept of joint Hindu family property began. So, whenever there is an issue of partition of a joint Hindu family property, we need to understand that what exactly is the co-partnership and who all are the members of the co-partnership. So, prior to the amendment in 2005, the co-partnership property and this concept was dominated by only male members in the family. So there would be one karta, then below the karta would be the sons of the karta, below the sons would be the grandsons of the karta, and below the grandsons would be the great grandsons of the karta. So the co-partnership would have one karta and then three down the lines and three lines down in the succession, son, grandson, and great grandson. And they were all male members of the family who would be having right to share and claim partition in respect to any joint Hindu family property, a co-partnership property. Now, after the amendment in 2005, the parliament of our country, they came out with an amendment in section 6 of Hindu Succession Act 1956, and for the first time in the country as a whole, it was declared that the daughters in the family shall also be having equal rights as that of a son in the joint Hindu family properties, co-partnership properties. So now the co-partnership will consist of not only the sons, it will also comprise of daughters as equal claimants in respect to a joint Hindu family property. Now, to say this is all very simple and it will appear as if we are understanding everything. But when we go into the details and intricacies, then the very first issue arose as to the application of this Amendment Act, because the Amendment Act came into effect from 9 September 2005. So the issue arose about the prospectiveness or retrospectiveness of this amendment. And from 2005, these issues developed, and from various high courts, they went up to Honorable Supreme Court. And here, the learned audience may note down the judgment came in the year 2015 from the Honorable Supreme Court. The exact date is 16th October 2015, and the title of the case is Prakash versus Fulavati. There, the Honorable Supreme Court held that the Amendment Act 2005 shall apply in prospective. And what exactly did they mean by saying prospective? That both the father co-partner and the daughter both should be alive as on 9 September 2005 in case of daughter claiming any share or claiming any partition of the joint Hindu family property on the basis of the Amendment Act. So what it means that if the father of the lady of the daughter had already expired before 9 September 2005, then the Amendment Act will not apply. Then, thereafter, another judgment came in the year 2018, and the date of that judgment of pronouncement was 1st of February 2018, and the case was popularly known as the Namma. The Namma was the first name of the title of the case versus Amar. Now, in this case, the Honorable Court took a different view, and they held that the application of the Amendment Act is retrospective. So they wanted to give the Honorable Supreme Court, after discussing all the laws and the other judgments pronounced before, that the law shall be applicable in retrospective manner. And as our learned moderator, Mr. Sunil Gupta ji, has mentioned that the last word on this law has now come from Honorable Supreme Court in last year only, 2020, and exact date is 11th August 2020, in the judgment titled Vinita Sharma versus Rakesh Sharma. And in this judgment, which is a very exhaustive and a detailed piece of law, the judgment of Prakash versus Fulavati has been overruled, and the judgment of Danamma has been partly overruled. And this time, the Honorable Supreme Court has coined a very special term. Neither the Supreme Court has called it prospective nor retrospective, rather, they have termed it as retroactive. So, to understand it in simple terms, now the position is that as on 9 September 2005, if there is a joint Hindu family property existing and there is a daughter who's alive as on 9 September 2005, then the Hindu Succession Amendment Act will be applicable fully, and the daughter shall have complete rights to ask for her share in that joint Hindu family property, irrespective of the fact whether the father co-partner through whom she is claiming her right has died before 9 September 2005 or he is alive. At the same time, the daughter may have been born before 9 September 2005 or she may have been born after 9 September 2005. That will also not have any impact. The daughter should be existing and alive as on 9 September 2005 and after to claim her rights in the joint Hindu family property. Now, with this clarity about the application of the Amendment Act, as Honorable Supreme Court in the judgment of Vinita Sharma, The joint Hindu family property concept has been from time immemorial, and even hundreds of years back, when the Hindu Succession Act 1956 came, the law of co-partnery under Mitakshara law had always been there, but it was not codified. Now, as I said in the beginning, that in simple terms, any property which is coming to me or which is coming in the family from our ancestors, one generation above, two generation above, three generation above, then that property is always treated as a joint Hindu family property. Now, over the period when there have been cases filed in the courts and there have been disputes in respect to partition of a joint Hindu family property, the pleadings of the parties play a very important role. So, when a daughter or a son approaches the court claiming a particular property to be a joint family property or an HUF property or a co-partnery property, the pleadings of the party who's approaching the court, that is the plaintiff, they have to be very, very clear and specific that how the property is called to be a joint Hindu family property. Because many times it has happened that the property may have belonged to one of the members of the family as his own self acquired property, and differences may arise that the son or the daughter or the grandson or the great grandson, they may claim that this property is a joint Hindu family property. So to this aspect, there must be very clear and specific pleadings how the property is joint Hindu family property, how the property came into origin, who owned the property at that time, how the property became a joint Hindu family property. All those details have to be mentioned in the plaint very, very clearly and very, very specifically. And in this regard, there have been some very good judgments which have laid emphasis on this aspect. And in this regard, our Delhi High Court, Honorable Delhi High Court, laid down a lot of stress on this aspect in the judgment Sunny and another versus Raj Singh, followed by Surender Kumar versus Dhaniram and others in the year 2016 and in the year 2015. And these judgments have laid down this law with respect to the pleadings when any plaintiff approaches the court asking for any partition of a joint Hindu family property, that the details have to be given very, very clearly how the property came into existence, who owned the property, how the property over the years was either declared as a joint Hindu family property, thrown into a hodgepodge, and it was how treated by the whole family as a joint Hindu family property. Because if a suit is wrongly filed without these details, then the chances are that the court may dismiss the suit in the very beginning and may not entertain the claim. So, to understand the concept of a joint Hindu family property, we need clarity that who was the common ancestor who acquired the property for the first time, and how the property continued to remain joint family property after the death of that common ancestor, and how after one generation or two generation the property has remained as a joint Hindu family property. And with all those pleadings, a suit is filed and is tried before the court. Now, in this respect, when we look at section 6 of Hindu Succession Amendment Act 2005, there is another aspect which is important in this regard, that the provisions of section 6 subsection 1 read with its proviso. So if my learned audience have Hindu Succession Amendment Act with them, or they may just make a note of it, section 6 subsection 1 read with its proviso, and also read with section 6 subsection 5 read with the explanation. The legislature has tried to make it clear that if there has already been a partition in the family in respect to a joint Hindu family property, and that partition has already taken place on or before 20th December 2004. So this becomes another important date which you may kindly note down: 20th December 2004. Now this was the date when the Amendment Act was tabled in Rajya Sabha. So in the Amendment Act section 6, the legislature had very clearly laid down that if the joint Hindu family property or the co-parsonary property has been already partitioned amongst the family members on or before this date, but that partition has to take place under a registered deed of partition. So the legislature had been conscious that when they were excluding the partition of a joint Hindu family property, then that partition should be by a registered instrument of partition. Or second category of such cases may be under the final decree of a court. If under the final decree of a court, partition has already been ordered and partition has taken place, then that property will not be considered for purposes of claiming any right and partition by a daughter after 9 September 2005. So in this regard, section 6 subsection 1 read with the proviso and section 6 subsection 5 read with its explanation. And if my learned audience may like, I may just read it in brief. Section 6 starts with devolution of interest in co-parsonary property, and subsection 1 says on and from the commencement of Hindu Succession Amendment Act 2005, in a joint Hindu family governed by Mitakshara law, the daughter of a co-partner shall, and then ABC provides that a daughter shall have equal rights by her birth as that of a son. Now the proviso is important. Provided that nothing contained in this subsection shall affect or invalidate any disposition or alienation, including any partition or testamentary disposition of property which had taken place before 20th December 2004. And now when we go to section 6 subsection 5, it reads, nothing contained in this section shall apply to a partition which has been effected before 20th day of December 2004. And the explanation: for the purposes of this section, partition means any partition made by execution of a deed of partition duly registered under the Registration Act 1908 or partition affected by a decree of the court. So all the learned audience may just keep a note of this, that when the daughter has been given right equal to that of a son to claim partition and to claim her share in a joint Hindu family property, there is an exception. The exception is in respect to those properties where partition has already taken place on or before 20th December 2004, and that partition by a registered deed of partition under the Registration Act, or it may be under the decree of a court. So with this background, we have tried to understand a joint Hindu family property and how the daughters have been now from 2005 given the rights to claim their share and ask for partition in respect to a joint Hindu family property. Then I have also explained you in brief that the pleadings set up by the plaintiff who approaches the court for claiming share and for claiming partition, whether as a son or as a daughter, in respect of a joint Hindu family property, then the pleadings have to be very clear and specific about the nature of the property, that how such property is claimed to be a joint Hindu family property. So all the details have to be given: how the property was originally acquired, who had acquired, and how over the years, one generation after another, the property continued to be treated and accepted in the family as a joint Hindu family property. And only on those properties that the law will apply. The law will not apply in respect of any self acquired property of any Hindu, and that property will not be covered by Section 6. Now, in the Honorable Supreme Court judgment of Vinita Sharma, when this exception was dealt with, as laid down in Section 6, subsection 1, read with the proviso, and Section 6, subsection 5, read with the explanation, there was a plea set up, and there was a lot of discussions and lengthy submissions, that what shall happen in case the partition had taken place in the family orally, because our Hindu law and the various judgments of the Honorable Supreme Court of India have given cognizance and recognized even oral partitions in Hindu families in respect to their joint family properties and ancestral properties and co-passionary properties. So there have been a big series and catena of judgments on this aspect, whether the partition every time taking place in a joint Hindu family property is to be registered. So there have been judgments to the effect that in case of a joint Hindu family property, there can be an oral partition. So when this plea was raised before the Honorable Supreme Court, when the judgment of Vinita Sharma was to be pronounced, the Honorable Supreme Court has given uh, a finding that in very exceptional cases, if there has been an oral partition and that partition is supported with strong documents and relevant material and evidence, then it may also be considered to be excluded from the claim of partition by the son or the daughter. So, this you may find in para 127 and 128 of the judgment, where the Honorable Supreme Court has said the court may recognize other mode of partition in exceptional cases based upon continuous evidence for a long time in the shape of public document, not mere stray entries, and then only it would not be in consonance with the spirit of the provisions of Section 6, subsection 5, and its explanation. So, in very, very exceptional cases where a party sets up the defense and a plea of oral partition against the claim of partition by a daughter, then it may be shown to the satisfaction of the Honorable Court that the oral partition is supported by very strong documents, material, evidence running over the long number of years to convince the court that this property has already been partitioned amongst the family members and it is no more open for anybody to claim any share and partition of such property. So, with this, and I think for your common understanding, I may also give you a small description that whenever there is a death of a Hindu male or a Hindu female, that the issues of inheritance and succession arise. So now you may just understand that there may be a case where the Hindu male or Hindu female has left behind a will. Then the succession will take place according to the will of the testator, the deceased testator. This is called testamentary succession. In case the deceased male Hindu or deceased female Hindu has died without leaving behind a will, then it is called intestate succession. So this is irrespective of a joint Hindu family property or a self-acquired property. This is general understanding of law of succession, that on the death of a Hindu, succession opens. Now it may be death of a male Hindu, it may be death of a female Hindu. Then there may be a will left behind, it will be a testamentary succession. If there is no will left behind, then there is an intestate succession. Now, in case of an intestate succession, there would be two situations. Either there would be a self property of that male Hindu or female Hindu, or there would be a joint Hindu family property in the hands of that male Hindu or female Hindu. So, in respect of self acquired properties, which is not our subject today, but I am just trying to share with you little more knowledge on this subject, that when it is the case of a self property and the death of a male Hindu happens, then the devolution and inheritance and succession of that property is governed by Section 8 of Hindu Succession Act. And there you will find there are class 1 legal heirs, class 2 legal heirs, and then agnates and cognates. So that will be case of a self property of a male Hindu who has died intestate without any will. Then the legal heirs who shall be entitled to be inheriting that property would be falling in class 1 legal heir. If there is no legal heir of class 1, then the legal heirs of class 2. And if there are no legal heirs of class 2, then those who fall in the category of agnates, and this all is given in Hindu Succession Act schedule, which you all can always refer to and read. Now, in case of a female Hindu dying intestate and a self property, then it shall be section 15 and section 16. So in section 15 and section 16, they have provided who all shall be entitled to inherit the property of a female Hindu who has died intestate and the property left behind her was her self-acquired property. Then the other case is of a co-partnership property, because this was intestate succession of a self-acquired property. Now there may be a case of intestate succession of a joint Hindu family property, and it is this subject where section 6 becomes relevant and applicable. And as we have discussed, according to section 6, both son and daughter shall have equal rights. Now, after having said all this, there are still some issues which have been left to be addressed, and maybe in the coming time that those issues may also arise, because as I said in the beginning, that a coparcenary comprises of one ancestor, the oldest and the first person from whom the joint Hindu family property began. And under that ancestor, who's commonly also called as Karta, there are three lines of succession, including sons, grandsons, and great grandsons. Now, after the amendment, the daughters have also joined in the first line of succession with the sons. But I am still not clear, and maybe we'll have this issue also in the coming years, that what happens to the second line of succession where you have grandsons, then do you also have grandsons from the daughter side, or do you have the granddaughters from the daughter side and from the son side? Because if the daughter, there is no discussion on the subject of granddaughters as on date, and great granddaughters, though in the co-pastary the grandsons are admittedly co-partners and members of the co-partnery, and great grandsons are also the members of the co-partnery. But we still have to see what shall be the rights of the children of a daughter. If suppose the daughter has is not alive on 9 September 2005, and her son is alive, or her daughter is alive, and if they have to claim share in the joint Hindu family property as son of a predeceased daughter, then what shall be the position? That may still be a question that may be examined sometime in future. But as of now, the entire discussion on Hindu Succession Amendment Act 2005, Section 6, is confined to daughters, and there is no mention of granddaughters or great granddaughters, either from son side or from the daughter side. So, with this, I feel that for our purposes of today's discussion, and if you have, and I may request the learned moderator, Mr. Sunil Gupta ji, to come in and take us forward on any queries and any questions from the dear audience.
Yes, sir. Uh, Sir, we have received one query from Miss Rakshita Mishra, and her
Ji.
query is what procedure is followed when the testator died in another country who was residing in that country having permanent residency of that country?
No, then the question may not be complete, in the sense that firstly it doesn't relate to our today's discussion of right of daughters. Now, if any Hindu person has been living abroad, it has to be seen whether he has acquired the citizenship of that country already, or is he still a citizen of India and enjoying the status of NRI, non-resident Indian. Because if he has already become the citizen of that other country, then the law of successions of that country will apply on him, and Hindu law may not have any impact. But in case he is only a non-resident Indian and he continues to be a citizen of India, and the property is in that country, is it situated in that country? In her question,
There is no clarity qua this.
so it will also depend. The second issue would be, where does the property situated? If it is situated in the foreign country, then it won't apply. Then our Hindu law won't apply there at all. So for Hindu law to be applying, the person living abroad should be firstly an Indian citizen, and secondly, the property should also be situated in India. Am I clear on this?
Yes, sir. Yes. Sir, next question is by Mr. Vinay Prakash Singh, and his question is whether one can relinquish his share of co-partner property. If yes, then what should be the nature of property?
You see, the question is that there is a joint Hindu family property, and there may be so many members in the co-partnery, including sons, grandsons, great grandsons, daughters. Now, any of the member in the co-partnery can always give up his rights and interests with respect to his share by way of a registered relinquishment deed, and there is no prohibition on that. A relinquishment deed is a document which can be executed and registered under the Registration Act, and he can or she can always give up her rights and interests and share in that joint Hindu family property.
Ji, sir. Sir, next question is by Madam Neetu Sindhi, and her query is whether self-acquired property of father or grandfather after coming into force of Hindu Succession Act be treated as joint Hindu family property.
See, if the self acquired properties of the father, and if the father dies, then that self acquired property of the father will devolve, as I said, according to Section 8 of Hindu Succession Act. If it is an intestate succession, there is no will left by the father, and that will be class 1 and class 2, and as forward, agnates and cognates. So if the property was a self acquired property of the father, he has died intestate without leaving a will, then Section 8 will govern. It will not be a case of joint Hindu family property. But if the property belonged to the grandfather and the grandfather has died, and if the partition of that property has not taken place, then the property, unless it has been partitioned earlier, and if it has continued to exist after 9th of September 2005, then that property of the grandfather in the hands of my father, or maybe his brothers and his sisters, and then the grandchildren, then this may be a case of a joint Hindu family property, and it may be divided or partitioned as a joint Hindu family property by Section 6 of Hindu Succession Amendment Act 2005.
Ji sir. Sir, next question is by Advocate Meena Jha. Her question is, if the partition is done, what is the right of a son to that property, whether it is treated as his self-acquired property or in any other manner?
No, see, if it is a self acquired property, then, as I said earlier, class 1 legal heirs will be entitled to inherit the property in equal shares. So, if there is one son, he shall acquire the entire property. If there are two sons, they will get half share. If there are three children, all the daughters, all the sons, they will have equal share in a self acquired property. If the male Hindu or the father has died in respect of a self acquired property. If the property was an ancestral property in the hands of the father, that means the father has got the rights in the property from his father, which is the grandfather. Then that property will be a joint Hindu family property. Then, on the death of the father, this joint Hindu family property shall devolve as per Section 6 to all the members of the co-partnery, including the sons and daughters, grandsons and great grandsons.
Ji sir. Sir, next question is by Ms. Vaishali Deshpande, and her query is a daughter co-partner in property if she is married prior to the year 2005?
No problem. See, daughter may be married, daughter may be unmarried, daughter may be minor, daughter may be major. There may be a widow daughter also. So it is not going to have any difference if the daughter has already got married. She continues to remain a daughter for the family, whether married or unmarried. So daughter alone is sufficient for purposes of Hindu Succession Amendment Act 2005 to claim share in the joint Hindu family property.
Ji sir. Sir, next query is by Mr. Rupesh Sharma, and his question is, if a husband dies, what are the remedies available for widow wife of the deceased husband? What are the legal remedies available to seek share in the husband's property?
No, see, if the death of a husband take place, then wife is already a class 1 legal heir. So the property will devolve upon the wife and her children in equal shares. So this will be a case of a self-acquired property. If it is a case of a self-acquired property of a husband, then after the death of the husband, the property will devolve upon the wife and the children in equal shares as per class 1 of the schedule of Hindu Succession Amendment Act.
Yes, sir. Sir, next question is by Mr. Vinay Kumar, and his question is, if any joint Hindu property was sold after 9th of September 2005, can a daughter claim her share in the same?
Oh, okay. See, this may be a little complex matter. If the property was admittedly a joint Hindu family property, then the property belong to the family and to all the co-partners, including the three generations of co-partners. Now, if any of such property has been sold, now let us assume that it has been sold by any one member of the family. And if that one member of the family has taken and kept all the money and the sale proceeds all to himself without sharing it and giving it to all the other members, then it may be a case of misconduct on the part of that member. And there can always be a dispute raised by the other members, including the son and daughters, to ask for setting aside of that sale, or at least for the share proceeds to be distributed, unless it can be shown and proved in the court of law that the property was sold with the consent and approval of all the co-partners and members of the joint Hindu family, or it may be shown that it was in the welfare and as a necessity for the whole family. And normally, such cases arise when the property is sold by Karta. Karta is the senior eldest member of the co-partner. So, in exceptional cases, Karta has the power to sell the property when it is of utmost necessity and for the welfare of the whole family, or with the consent and approval of all the co-partners and family. Otherwise, this may be a wrong. This may be a wrong act of sale of a joint into family property by any one individual member, excluding the other members. And that sale may be challenged and finally it may be set aside by the court of law.
Yes, sir. So next question is by Miss Mohini Kashyap, and her query is the Hindu Succession Act applicable on agricultural land, or it affects Delhi Land Reforms Act?
See, my knowledge says what I have read that after the Hindu Succession Amendment Act 2005, the provisions are applicable now even in respect of agricultural lands in the country. Earlier, Hindu Succession Act 1956, there were some provisions of excluding agriculture properties from joint Hindu family property. Now there's a judgment of division bench, Honorable Delhi High Court, where they have considered agriculture properties also to be included in the joint family properties.
Yes, sir. So next question is by Miss Shomendu Mukherjee, and her query is: if she, as a first-class female here, receives her share, then after her death, will her share go back to the joint family pool or get divided among her
No,
legal?
no, no, no. If any property has been inherited on the death of a deceased Hindu, male or female, I think it will be a male because she's in a question saying class one. So if it is a case of inheritance by any one heir in class one, then property will never go back as a joint Hindu family property because that is her own separate property. As a class one legal heir, if I inherit any property, then it becomes my individual, my own property.
Yes, sir. So next question is by Advocate Irshad Siddiqui, and his question is: can a grandson claim share in ancestral property if the father did not claim his share and the property has been divided earlier?
No, if the property has been already divided earlier, then he may not be able to claim partition because the other side against whom he will claim partition, they will come and show that this property has already been divided. Unless the property is already existing and there has no partition taken place, then only there will be a situation that a son or a grandson shall have the right to claim his share and file a suit for partition. If the partition has already taken place and all the family and all the co-partners have received their share, then there may not be any remedy of partition further available.
Yes, sir. So next question is from Mr. Bharat Tokas, and his question is: if daughters made RD in favor of their mother after the death of their father, and mother made will in favor of sons only, then in case mother dies, can the daughters claim their share from sons and challenge the will?
Now, this is a very, very complex and a very interesting question that the lawyer has raised, because many times there have come cases where, on the death of the father, all the daughters and the sons, they have relinquished their share in favor of the mother. So these relinquishments are taking place even now under the advice of the senior family members and well wishers, that when the mother is alive, then all the properties be treated as properties belonging to the mother, and relinquishment deeds are done not only by the daughters but also by the sons. So now, if the daughters have relinquished their shares, their interest, their rights in the property of their father in favor of their mother, and those relinquishment deeds are genuine, they are in all respect legal by registered instrument, then the mother becomes the absolute owner. And after the mother becomes the absolute owner, she has absolute rights to deal with that property in her own choice and manner. And if she makes a will in favor of a son, and if the will is also genuine and true according to the Indian Succession Act, then daughters may not have a strong case to challenge it later that mother could not execute the will, because once they have given the relinquishment deeds with all understanding and with all clarity in their mind that they are giving up their share for all times to come, then even if the mother has given a will in favor of any one son or two sons and excluding the daughters, then daughters may have a very difficult case to succeed.
Yes, sir. So next question is by Mr. Nitish, and his question is: if the will of ancestral and self-acquired property has been registered after the amendment of Section 6 of Hindu Succession Act, whether the married daughter can still claim her share?
See, as I said earlier, also, marriage of the daughter makes no difference. For purposes of claiming share or partition in a joint Hindu family property, daughter may be unmarried, daughter may be married. So that difference will not arise. The only thing to be seen is that the property continues to exist as a joint Hindu family property, and there is a daughter who's married or unmarried, she will have a right to claim share and partition.
Yes, sir. So next question is by Mr. Sachin Sharma. His question is: how the property of a grandfather or great grandfather shall be divided among his sons or grandsons?
See, that will be a simple thing. You have to draw a co-partnery on a piece of paper. You have to see that after the death of the ancestor, the grandfather or the great grandfather, who are all the co-partners alive today, whether the sons, grandsons, great grandsons, and daughters, all of them together who are alive, they would be entitled to get equal share in the property.
Sir, next question is very interesting one from Mr. Aman Chopra, and his question is: if a father disowns his son, will the grandsons, children of that particular son who has been disowned, have the right in property being grandsons?
See, this will depend whether the property is a self acquired property or a joint Hindu family property, because this is not clear in the question.
Yes.
But in any case, if we consider that the property belonged to the grandfather, then then I think what the learned A querist is saying that this property belonged to the grandfather as his self property. And if the grandfather has disowned his son, that is my father. And if the grandfather is alive, and if the property is the self property of the grandfather, and if the grandfather dies, then the inheritance would be as per section 8 as a self acquired property, intestate succession. And the grandson, that is, he may be falling in class 1 legal heir, or he may be falling in class 2. It will all depend upon that. But if it is a joint Hindu family property, in the sense that grandfather was the owner, and during the lifetime of the grandfather, this property was thrown in a joint Hindu family system, and if the property was accepted in the family as a joint Hindu family property, then the grandson, irrespective that his father had been disowned by his grandfather, he would always have a right in that property to claim his share and interest.
Ji, sir. Sir, next query is from Miss Mohini Kashyap, and she is requesting for the judgment or any citation related to agricultural land where the Succession Act is, it says that Succession Act is also applicable.
Okay. So for this purpose, I'll request the learned moderator to kindly share my contact number or my mail ID with the learned querist, and maybe I
Ji.
shall be able to give her the citation after some time.
Sure, sir. Sure, sir. Sir, next question is from Mr. Amit Dhama, and his question is: in villages, generally in revenue record, after the death of father, some son's name are recorded instead of father's in revenue record, whether the property is still joint property or divided accordingly.
See, as I said earlier, a property to be held to be a self acquired or a joint Hindu family property, there must be a past of that property. So, if the details of the property show that the property was acquired by any senior member of the family, a common ancestor, or the first generation, or the two generations above, and if the property had been accepted in the family as a joint Hindu family property, and there are sufficient material and evidence to show that this was always accepted to be a joint Hindu family property, then it will be a joint Hindu family property. But if there are no supporting material, documents, evidence, and if it shows that the property belonged always to one individual as his self acquired property, whether an agricultural land or any other non agricultural property, then that will be a case of a self acquired property.
Sir, next question is by Mr. Shakil Ahmad, and his question is: if a Hindu son can claim partition in self-acquired property of his father.
Correct. See, if a father, now see, this will be not when the father is alive, because if father is alive and there is a self acquired property of the father, nobody can claim any partition, and father has all the liberty and choice and freedom to do whatever he wants with that property, whether he may sell it off, or he may give it to anybody, gift it, or he may give by any will or disposition. Only after the father dies and there is a self acquired property of the father, then there may be a situation where the property may need to be partitioned or divided amongst the class 1 legal heirs.
Yes, sir. Sir, now we are going to our last question for today. And the question is: if the mother disowns her son after the death of her husband, is he entitled to his share in the property?
See, let me tell you very frankly that this disowning, this concept of disowning a son by the father or by the mother, is a very complex subject. And On the face of it, it appears that if the mother has disowned her son and excluded her, then either she may have to execute a will, and in her will, she may have to exclude that son, and she may give her property to any other legal heir. Then it will be more effective. But during her lifetime, if she has disowned, then it's only a matter of record that she has disowned, because the occasion of any partition will not arise when the mother is alive. So the best course would be that if the mother is so much against the son that she has disowned him, then she may also execute her will and have it registered. And in that will, the disowning may also be confirmed, and property may be then given to any other legal heir. Then it will complete the process. And then, after the death of the mother, the son who has been disowned may not have any right to claim any share in her property.
Yes, sir. Sir, there is one more question. It is by Mr. Anurag Parashar, and his question is whether plaintiff who has filed a suit for partition must also seek additional relief for declaration when the defendant takes defense that he acquired the suit property through registered will.
See, when the plaintiff files a suit for partition, he files it for partition. And it is not that how the defendant will file his written statement and thereafter he will then amend the plaint. You have to set up your own case in your plaint, that whether the property is a self-acquired property of which you are claiming partition, or it may be a property joint Hindu family property. So when you are claiming a partition, you have to set up your case very clearly and specifically about the nature of the property and how you as a plaintiff have got a share in that property, and how it is that you are entitled to claim partition of the property. That much is sufficient and enough. Whatever defense the other side is going to take, that will be for the defendant to prove his case. So it doesn't matter, and there may not be any need for plaintiff to ask for any declaration, depending upon what the defendant is going to say in his written statement or reply. You have to be strong in your own case about the nature of the property and about your rights to claim share and partition in that property.
Yes, sir. Sir, we have received another question just now, and it is if I purchase a property with my mother, after the death of my mother, what will happen to her share? Will I also get 50% share along with my sister? So,
Yes, this is very simple. If you have purchased a property with your mother, now it may be generally half that you have paid half the money, your mother has paid half the money, and the property is in joint names. So half the property already belongs to you. Now when the mother dies, her half share in the property will again go to both the children, that is the son and the daughter. So the son may become 75% owner, and the daughter may have 25% share in the property.
sir, thank you very much. So, this was the last question. We are left with no more questions.
Okay,
And as I said earlier, we were sure that your session is going to be a great, informative session for all of us, and it has turned out to be so.
no,
So,
no,
thank you
thank you.
once again for sparing your valuable time and for agreeing to our request to
No,
become a resource person on
no, thank
such a interesting and important aspect of practice.
Thank you,
So,
thank you very much, Sunilji, for giving me this opportunity, because I have always believed that sharing knowledge increases the knowledge. So I always look for an opportunity where I can be of any help and I can share any piece of knowledge with the learned audience at any time, at any in any situation. And with the and I thank DSLSA and the platform of DSLSA for inviting me and giving this chance and opportunity. And thanks very much to you for your kind moderation of this session, and I hope the learned audience have gained something from this session.
Of course, sir. I don't think there can be any doubt in that. And I'm sure कि आगे भी जब कभी हम आपसे request करेंगे, you will spare time for us and be ready for sessions to be held in future.
All right, Sunil ji.
Thank
Zarur,
you.
zarur.
And
Thank you.
I thank all the learned legal service advocates who have joined the session today for sparing their time and for raising such pertinent questions. I also thank the technical team without whose help this session would not have become possible. So thank you once again. Good evening.
Thank you, Sunil ji. Thank you very much. Thank you very much.